So, what happens when a factory in one country starts causing problems for its neighbors in another? Today, we're diving into a case that answered that very question. It's called the Smelter case, and it literally rewrote the rulebook for global environmental responsibility.
And you can see from this quote, this wasn't some quick fix. Back in 1935, both the United States and Canada knew they were dealing with a serious, ongoing problem, one that absolutely demanded what they called a permanent settlement. Here's how we're going to walk through it. First, we'll look at the source of this invisible invasion. Then we'll trace how a local complaint grew into an international issue. We'll see the pretty unique way the two countries chose to handle it, look at the historic ruling, and finally unpack the new global principle it established.
Okay, so let's set the scene. Our story starts right on the Canada-US border. You've got this massive industrial plant on one side, and on the other, some very unsuspecting neighbors.
The geography here is simple, but it's absolutely key to the whole story. In a town called Trail, in Canada, there was one of the largest smelters on the continent. And just 7 miles south, right across the border in Washington state, was this quiet, rural area, a community that really depended on its farms and forests.
So what was the issue? Well, by 1930, that smelter was pumping out a staggering 10,000 tons of sulfur. And that's not per year. That was every single month.
To put that into perspective, that's more than 300 tons of sulfur a day. And when that hits the air, it becomes more than 600 tons of sulfur dioxide gas. It was this invisible cloud that would just drift south, carried by the wind, right down the Columbia River Valley.
But that invisible cloud didn't stay invisible for very long. It started causing real, visible damage. And that damage sparked a cross-border complaint that would eventually become a major international dispute.
You can really see how this thing snowballed. It started with local farmers back in 1925. Just 3 years later, it was a diplomatic issue. They tried to fix it with a payment of $350,000, but that didn't stop the pollution. The damage kept happening, and by 1935, both governments knew they needed a final, binding solution.
And the U.S. wasn't just talking about damaged crops. The claim was that these fumes were harming pretty much everything. Cleared farmland, forests, livestock, even property in the nearby town of Northport. Not to mention the local businesses that were suffering as the whole area's economy took a hit.
Now, with tensions this high, things could have gotten ugly. But instead of escalating the fight, the US and Canada chose this really remarkable path of cooperation. They came up with a unique solution, one tribunal to solve the problem for two nations.
And this right here is the turning point. Instead of letting this dispute tear them apart, they agreed to build a special panel to find a fair and final answer. Honestly, this was a pretty pioneering move in international relations at the time.
So what is an arbitral tribunal? You can think of it like a custom-built court. It was a panel of 3 judges, 1 American, 1 Canadian, and a neutral chairman from Belgium, all chosen specifically for this one case. And whatever they decided, that was it. It was final.
The two countries didn't just tell the tribunal to go solve this. No, they gave it a very specific job, which was broken down into 4 precise questions that it had to answer. These 4 questions were its entire mission. First, prove the damage happened after that initial payment and figure out how much it was worth. Second, decide if the smelter had to stop causing harm in the future. Third, okay, how should it stop? And finally, fourth, should there be any compensation for the cost of those new preventative measures? It was a complete roadmap.
So with that 4-question mission in hand, the tribunal got down to business. After years of investigation, it delivered its landmark ruling, and this decision would have effects that lasted for generations. Everything really hinged on this first question. Was the Trail smelter still the problem after that 1931 payment? Canada argued there were other things to blame. You know, insects, drought, fires. The U.S. had to prove, conclusively, that the smelter was the source.
And the tribunal's answer was crystal clear. Yes. Based on scientific evidence and observations on the ground, they stated in no uncertain terms that damage had occurred. That conclusion was the foundation for everything else that came next.
So with the cause established, the tribunal moved on to the money part of question 1. It awarded an additional $78,000 in indemnity. This was specifically for the damage to cleared and uncleared land that had happened between 1932 and 1937.
But, and this is important, the tribunal was very careful. It didn't just approve everything the U.S. asked for. It actually rejected several claims for livestock, for property in the town, and for business losses, finding that the evidence was either too indirect or just not strong enough. This really shows how meticulously they weighed the proof for each and every claim.
But this case wasn't just about the $78,000, not at all. Its most lasting legacy was the creation of a powerful new principle in international law, a new global rule that we still rely on today.
This slide sums it up perfectly. Before this case, the rules on cross-border pollution were, well, murky at best. But after this case, the principle became clear. No state has the right to use its territory in a way that causes serious injury to another state. A country is responsible for what comes from its land. And the solution was so forward-thinking. The tribunal didn't just point fingers. It created a detailed, science-based system, a regime, to actively monitor and manage future emissions. This became a model for how to solve these kinds of problems proactively, not just punish them after the damage is done.
So here's the bottom line. A fight over sulfur fumes almost 100 years ago gave us a foundational rule for how countries have to respect each other's environment. And it really makes you think, from carbon emissions to the flow of digital data, what new invisible borders are we crossing today, and what new rules will we need to invent for them?